Trial resumed. Jury not present.
The court said, "Good morning."
Ms. Shrofa said, "Good morning, Your Honor."
Mr. Horton said, "Good morning, Your Honor."
The court said, "Would you make your appearances, please?"
Mr. Horton said, "Good morning, Your Honor. Justin Horton, for the government. I'll be joined shortly by AUSAs Murray and Finkel."
Ms. Shrofa said, "Good morning, Your Honor. On behalf of Mr. Guo, standing to my left, Sabrina Shroff. Start?"
The court said, "Please be seated. Is there anything that you want to bring up before we?"
Mr. Horton said, "Just a brief timing matter, Your Honor. The government would ask for 15 minutes, 10 minutes. Between the conclusion of the defense summation so we can set up and move things around for the rebuttal."
The court said, "And how long do you think the rebuttal will take?"
Mr. Horton said, "I think an hour."
The court said, "Okay. Anything from Ms. Shroff?"
Ms. Shrofa said, "Your Honor, I was told by my client that there was some incident at the jail yesterday. I haven't gotten to the bottom of it. If there is an issue, I'll raise it and ask the court for a second appearance. If need be. I don't know what it is."
The court said, "All right. Well, if you need me before 9:30, I'm here."
Ms. Shrofa said, "Thank you, Your Honor. I appreciate it. It may not, but I just don't know. Thank you."
The court said, "Okay."
Recess.
The court said, "Please have the jurors brought in."
Jury present.
The court said, "Please be seated. Good morning, jurors."
The jury said, "Good morning."
The court said, "We're now going to continue with the summation on behalf of Mr. Guo by Mr. Siddhartha Kamraju."
Mr. Kamraju said, "Thank you, Your Honor. May I proceed?"
The court said, "You may."
Mr. Kamraju said, "Thank you. Good morning. Welcome back. So when we left off yesterday, we were talking about G clubs. We just started. Now, G clubs feels like the piece of the case that the government spent the most time on at trial. You know, the cars and the campers and the mansion. All kinds of things that you might expect at a luxury membership club. So the first thing I'm going to ask you to consider at just a fundamental level is that all of those things, the cars, the house, the bikes, none of it actually matters. And why is that? Because I asked you to look through every single inch of that Shamal Medrano chart. I think Mr. Finkel said it was over 200 pages long. Look at every one. And you will not see a single promise or representation by G clubs or Mr. Guo about how the company would spend the money that it took in from the sale of memberships. Not a single one. And that makes sense, right? Because think about what Mr. Reyes thought G clubs was. It was a company that offered benefits and services to its members, right? You can see that, right? In the membership brochures. You get discounts at hotels and travel agencies, conferences like G Talks. Oh. And you remember Mr. Finkel said that the G Talk sweepstakes were rigged or staged because Mr. Guo's immigration lawyer won a car. Remember that during summation? Well, Ms. Reyes told you that she hired a third-party company to run the sweepstakes. Mr. Guo wasn't involved in that. So what was the rigging? But benefits. That's what G clubs offered its members in exchange for their membership payments. And those membership payments make up the company's revenue, the company's money. Think about it. It's no different than Netflix or Hulu or any other streaming service. You pay them $9.99 or whatever a month. For the ability to stream movies and shows or whatever, right? And after you pay that $9.99, it's gone. It belongs to the company now. And the people who run Hulu or Netflix, they can do what they want with it, right? So if the owner of Hulu wants to spend money from the company on a new car or a vacation or even a gift to someone else, there's nothing wrong with that. That's not the member's business. That's not your business if you're a Hulu member. In fact, you heard about that in this case from Ms. Reyes. It was the same for G clubs, just like for her new business. The owner of the business gets to decide how to spend the money. And ultimately, who is the owner of G Clubs? Haren he. You heard witness after witness say that. You saw document after document say that. He was the owner of G Clubs. And as you also saw, he approved every one of those purchases that the government is focused on here, the cars, the yachts, the transfers to Hamilton, the campers, all of it. So what's the issue here? The government wants you to believe that Mr. He is just a front. And that the real owners of G Clubs are either Milesun Guo or Mr. Guo himself. So let's start with Milesun. The government's entire case that he owned G Clubs comes down to some strange reference in one of those Khaled recordings where Milesun says that he's a settler of some Dutch trust. Did they give you any evidence as to what it means to be a settler of a trust, let alone a Dutch trust? Did they explain that term to you? How much significance can you give that term, when in the same call? Milesun also says, but Mr. He is the owner. And frankly, even if Milesun Guo does have some ownership interest in G Clubs, so what? Why would that fact change the basic principle that the owner of the business can use the money to buy what he wants? Right? Now let's look at the government's proof that Mr. Guo controlled G Clubs. What is that? Well, there's the testimony from Mr. Khaled where the government asked him whether it was true that Mr. Guo did not have decisive control over G Clubs. And he said no, that wasn't true. You remember his testimony. But did Mr. Khaled actually give you any examples of what decisive control means, of what Mr. Guo's control meant? Anything other than his say-so? And we'll talk about his credibility in a second, as well. But before that, remember, he didn't even really work at G Clubs. How would he know what was happening at the company? But when you look at the testimony of somebody who actually worked at G Clubs, Limari Reyes, who was the CEO, what did she tell you? She told you that she never took any direction from Mr. Guo at all. She viewed him as a spokesperson, as a trendsetter. That's it. Now, you can imagine what Ms. Murray is going to say when I sit down. No, Mr. Reyes may not have interacted with Mr. Guo. But she interacted with Ms. Wang, who, according to them, is Mr. Guo's lieutenant. But again, look at what Ms. Reyes said. When asked by Mr. Finkel on direct who Ms. Wang reported to, what Ms. Reyes said. She said Mr. He, not Mr. Guo. For all the control that Mr. Guo is supposed to have over Mr. Wang in G Clubs, the CEO of the company didn't even think of Mr. Guo as Ms. Wang's boss, let alone G Clubs' owner. And think, in particular, about one decision that G Clubs made, the posting of that disclaimer, right? Mr. Finkel talked about it. And he told you that Mr. Guo put that disclaimer in part as part of the scheme. I think his words were he put that document in place. But it doesn't make sense. So let's read the disclaimer. What does it say? It says, basically, take what Mr. Guo says with a grain of salt, right? You're not going to get any stock, you're not making investments. According to the government, all those statements would undercut Mr. Guo's goal of tricking people into buying G Club memberships, right? But according to Mr. Finkel and the government, Mr. Guo put that in as a cover story. There's one problem with that, you heard Ms. Reyes's testimony. She didn't even consult, sorry. Excuse me. Sorry. I have the wrong one. Well, we'll find it. But Ms. Reyes told you that she didn't even consult with Mr. Guo to put it in. She didn't even consult. It was her and the marketing team. That's what Ms. Reyes told you. Sorry, I got ahead of my slides. There it is. Were you responsible for any of the content that Mr. Finkel asked you about yesterday? The marketing team and I, yes. Okay. And you did that totally independent of Mr. Guo, right? We did not ask him. So think about it. Mr. Guo is the one who put this in place, but the marketing team and Ms. Reyes didn't even discuss it with him? And think about this, does it make any sense that if Ms. Reyes actually thought of Mr. Guo as her boss or as this implacable figure at G Clubs that you had to please? Would it make any sense that they would have put up this disclaimer without his approval, without asking him? Think about your own job. Would you put something up on your job's website that basically says, "Hey, feel free to ignore whatever my boss says"? Would you do that without even checking with your boss? No. Why? Because you'd get fired, right? The reason why they did this without Mr. Guo is because they didn't need Mr. Guo's approval to do it. Because Mr. Guo does not control G Clubs. It's that simple. So what's left? There are those recorded phone calls. Right, the ones that Mr. Khaled recorded without telling anyone. Now, the government says that the fact that Mr. Guo is on those calls is evidence that he's controlling G Clubs. So I want you to take a look at those calls again and think about the context. There's all this money flowing in. Right, from G Clubs members. It's stuck. There are complaints. And so the people who knew Mr. Khaled. The ones who had had a prior relationship with him, the ones, frankly, who had brought him in. They tried to talk to him and present options for getting the money unstuck. Okay. Send it back to the G Clubs account, right? Let's try that. Well. Can't do that because we don't have a G Clubs account. All right. How about this? How about we send it back to the people who sent it? Mr. Guo, the person with the intent to steal. According to the government says, let's give it back. But again, who shot that down? Mr. Khaled. Okay. We can't do that, how about you send it to Hamilton? Again, Mr. Khaled turned it down. Because the only thing he would accept is an agreement that kept the money with him so that he could keep making money off of it. Money that maybe he could use to buy a few more heirlooms, if you remember. And real quickly. You want to know how you know that Mr. Khaled lied to you from that stand? Well. After he got the agreement that he wanted, he still didn't do the job right, and G Clubs tried to fire him, right? Well, he sat there at that stand and told you, under oath, that after G Clubs tried to fire him, Mr. Khaled didn't even want to stay in the contract with G Clubs. He said that in July of 2021. He wanted to be done with the company. So if that's true, then why were his lawyers, at Mr. Khaled's direction, begging G Clubs to stay? This is the letter that his lawyer sent to G Clubs. We propose that G Clubs withdraw the notice of termination. Does this sound like Mr. Khaled is trying to get out of the deal? Of course not, because he lied to you. Because Mr. Khaled, the man who lied to banks, who lied on his mortgage applications, on his taxes, sat there and lied to you. So let's go back to the recorded calls. The money stuck and there was nothing they could do to shake it loose. And then you had that one call. The one with all the screaming, right? Remember Mr. Finkel opened his presentation with it. So let's talk about that call. Because while the government wants you to believe that they show Mr. Guo's control of G Clubs, in fact, they do the exact opposite. So first off, if you think that Mr. Guo is as big and bad as the government would tell you, then why were there so many phone calls in the first place? Mr. Khaled told you he was afraid of Mr. Guo. So if he is afraid of Mr. Guo, then you would think that one phone call from Mr. Guo, and this would be settled. It's all a scam, right? They can do whatever they want. So why is it when the boss, when the principal calls, it's over? They played recording after recording for you where nothing got done, even though Mr. Guo was angry. Even though Mr. Guo was yelling and screaming. And nothing got done. And look at the way those calls went. Just go back and look at the transcript. Everyone is explaining stuff to Mr. Guo. They are not giving in to him. No one is backing down to him. No one says, okay, Mr. Guo, whatever you want. They tell him no repeatedly. No. You can't do that. We can't do it that way. I know you want to do this, I know you want to do that. But we can't do it. Over and over again they tell him no. Is that the head of a racketeering enterprise? Is that the person who runs this massive fraud, the guy who keeps getting told no over and over again? And then yes. He loses his cool. But look at what happened before he loses his cool. Ms. Wang and Mr. Je say, look. We got to go to the board. We got to do this the right way. We got to go to Harenhe. And if you look at the call, Mr. Guo says okay. Even during all the screaming, all the yelling, he never says, screw you, you scumbag. We're not going to the board. You shameless bastard, how dare you propose that we go to the board? He doesn't say any of that. All he does is he gets angry. Okay. I think we all know that we get angry sometimes. But Mr. Guo does not direct them to change anything. And ultimately, Mr. Je and Ms. Wang do it exactly the way they want. They get the sign-off from Limari Reyes and Mr. He. And you see that in the government's own exhibits. So if those calls show anything, they show Mr. Guo's lack of control of these people, not the other way around. And I know the government says, well, okay, but why was he on these calls in the first place? He's a spokesperson. Well, let's talk about that. There's no doubt that Mr. Guo was a celebrity figure in the movement, and so in the G Club's member community as well. He was a spokesperson for the company. And just a quick note on that. Mr. Finkel commented on how, Mr. Guo is a spokesperson, but his contract didn't provide for any compensation. So think about that for a second. Mr. Guo is a fraudster, according to the government, the company is huge sham, right? There's millions of dollars there. Why not take a salary? According to them, you're broke. Think about how much money celebrity endorsers can make. So why not just take a few $1,000,000 as a salary? No one would have thought twice about it. It would have been easy to explain. He didn't do that. And the reason why he didn't do that is because Mr. Guo didn't care about the money, he cared about the movement. And that's why he was on those calls. Yes, we said in our opening statement that Mr. Guo was the movement. And the movement is him. And that's because it's true. And he was putting his name on the line for the movement while fending off the CCP's attempts to kill it in its infancy. So every misstep was a potential disaster for the movement. And G Clubs, which catered to the movement members, was supposed to help form the movement's social fabric, had a problem. So yes, Mr. Guo is on those calls. But that's because he was concerned about the impact on the movement and the dampening of the members' enthusiasm. He even says that in the calls. It wasn't money at stake, it was his life's work at risk. And if you had gone through everything Mr. Guo had gone through to bring the movement to that point, wouldn't you be involved? Wouldn't you want to make sure that things were going right? Wouldn't you want to make sure it was being pushed forward? Or would you just sit back and let someone like Mr. Khaled hold on to all of that money that did not belong to him? So why does this issue of control matter in the end? It matters because without it, the government has no way to connect Mr. Guo to what they said went wrong at G Clubs. They have no evidence that he controlled any aspect of the company's business. They called one G Club's employee at this trial, Ms. Reyes. And she told you she barely interacted with Mr. Guo and she didn't think of him as her boss. That was all Mr. He. And what's the government's only connection between Mr. Guo and Mr. He? What is it? Well, you remember Judge Torres in her instructions told you that just because you're friends with a criminal doesn't make you a criminal. Well, here, the government is saying that Mr. Guo is on the hook for actions of not even his friend, but his son's friend. And they are doing that without showing you a single communication between Mr. Guo and Mr. He. Or even a single communication between Milesun and Mr. He about G clubs. So how do they tie any of those acts? The Fiesta acts, the Ferrari, how do they tie any of those to this man, who's sitting in New York? Who has never had a single conversation with them about it? Because, trust me, if that evidence existed, don't you think they would put it in front of you? So what did they try to connect to him? The Lamborghinis and the mansions. Well, based on the paperwork and the government's witnesses, the most logical conclusion for both of those are their G Club's member benefits, not Mr. Guo's property. You remember Mr. Finkel asked Ms. Reyes about the G Club's website and how the company didn't offer those curated life experiences. Go back and look at that testimony. What did she actually say? She acknowledged the company didn't offer those experiences at the time. But she also said that they were working on it. And that's what you saw during her testimony. That G Clubs was trying to acquire benefits for its members also. And think about what was going on in the fall of 2020. The world was still in the grip of COVID, right? And as you heard Ms. Reyes testify, that made it hard to offer the full spectrum of benefits that you might anticipate at a luxury membership club, fancy restaurants, travel, hotels, experiences. All of that is nearly impossible with COVID. So yes, there weren't a lot of options for a luxury membership club trying to get off the ground. There's only so much you could offer your members at that time. But the company did what it could. It offered a significant discount on G Fashion. And that's a brand that you or I may not buy. But one that had special resonance with G Clubs' target audience. In fact, you saw how much money Mr. Zhou and Mr. Dai spent on it and saved on their G Fashion wear. Mr. Zhou came in here to tell you how he thought the clothing was poorly crafted or average. And even after he said he concluded that, he still spent thousands of dollars on it. Because he cared about the brand. Apparently, G Clubs offered a remote conference, G Talks, for members to hear from speakers of interest. And remember, that was the one with the do not say list, the do not say words list. I'm not exactly sure what the importance of that list is, because as you saw in those videos, Mr. Guo does have a way of going on when he speaks. And a reminder that maybe talking about prosecutors or the SEC wouldn't be the best idea while prosecutors and the SEC are investigating. And just a note on that. You may have missed it, but this is on the do not say list, voice of Guo, voice of good. So for all of that talk about how every G that you've heard about in this case is Mr. Guo's name, apparently, voice of good was used enough that they had to put it on this list. Think about that. This is a list that they say is supposed to go to Mr. Guo for words that he's not supposed to say. Things that they are worried that he might say. So they're worried he's going to talk about something called voice of good. You know why you're worried about it? Because you've used that term before. Because people have used that term before. So I know they mocked our witnesses and they said, oh, you're telling us that G isn't Guo. They're telling you that. Not just us. And there was one more thing though that the company offered its members right from the beginning. Ms. Reyes testified about it. The members felt like they were part of a community, right? They were bound by this common membership, a common outlook, for many of them even a common goal. And that's not about whether the G Clubs is formally a part of the NFSC or not. You cannot deny that the group had overlapping memberships. Wealthy Chinese people who had left China and were looking for an opportunity to bring about political change in their home country. And uniting together, that matters. Maybe not in ways that make sense to you and me, who don't have that same background, but still not in ways that are unusual or unfamiliar to us. We all value things for different reasons, right? Maybe you brave them as you're buying Mets tickets every year. Over and over again, because they are your grandfather's team. May not make sense to somebody, but you do it. Or maybe you pay for a museum membership because you feel linked to history that way. It may not hit the same for others, but it does for you. Or maybe you're active in politics because you feel good contributing to that cause, even though other people can't stand it. Many of us spend money on things that may not make sense to others for reasons that others don't have. But in the words of that old MasterCard commercial, the way it makes us feel, that's priceless. And so think about what happened in 2021. After the company had started working out its banking issues. You heard from Ms. Reyes, she started looking for different opportunities, right? She traveled to Europe to see if there are things that they could offer their members. And you saw those contracts that G clubs entered into for yachting opportunities and hotel stays. And you heard how Ms. Reyes scored that Formula I race opportunity. That would be a pretty cool trip if you could do it, right? And you also heard from Ms. Reyes that the company was buying luxury vehicles for its members to use. So in 2021, what did you see? Well, you saw that the company had bought a Lamborghini, right? This one. The one with the scissor doors. And you heard Ms. Reyes say that the car was supposed to be for G Club's members. After all, it was bought in G Club's name. And it was intended to be leased to G Club's members so that they could enjoy the thrill of driving it. So to sum it up, you have the CEO of G Club saying that the car was bought for G Club's members. Then you have the records from the dealership saying that the car was bought for G Clubs. So what is the argument? Why does the government say no, this was Mr. Guo's cars? For two reasons. Basically, the first is that on the day of Mr. Guo's arrest, March 15, 2023. The car was in Mr. Guo's garage in his home in Connecticut. And Mr. Finkel called that devastating evidence. Well, let's take a look at it. I think the best way to do it is to go through a chronology. So the car is bought September 13, 2021. You saw it was to be shipped to Connecticut. December 10, 2021. There's a video posted, the H-Coin to the Moon, that has a clip of Mr. Guo driving the car. Drives it about 10 feet near what it looks like his Connecticut home. And then sometime in 2022. Ms. Reyes testifies that she sees Mr. Guo showcase, that's her word, the Lamborghini in a video for G Clubs. And then on March 15, you have the FBI raid. That's the government's evidence right there. That's what they gave you. They have no evidence of Mr. Guo actually ever using the car other than for a prop on behalf of the Himalaya Exchange or G Clubs. No evidence of him joyriding in it, no taking it around the track in Italy. No witness testimony about him bragging about his new car. No evidence at all about where the car was even at during these periods. Where was the car between December 10, 2021 and sometime in 2022? Can they tell you? No. They have no idea. Where was the car in late 2022, when it was used for G Clubs and March 15, 2023? Do they know? They can't tell you. They gave you no evidence of it. Think about it. If that video was filmed in December of 2022, that car might have just been sitting there for a couple of months during the winter. Remember there was that battery charger at the Lamborghini witness testified about. So basically, at this point what the government has given you is that over a 2-year span, at most, 3 times that car was in Mr. Guo's home. And 2 of those times are tied to the filming of a promotional video for G Clubs, the company that owned it. And one of its corporate partners, the Himalaya Exchange. And the 3rd time. You have no idea when the car got there or how the car got there. But it's unlikely that it was there for Mr. Guo's personal benefit because there's no evidence that he drives. Even in the video you saw, he drove like 10 feet and he looked terrified. So ask yourself. Can you really tell what happened here based on the case the government has given you? Can you confidently say that Mr. Guo is right and that he stole money to buy this car that he parked in this house? No, you can't. Because it's at least as likely that Mr. Guo, a spokesperson for G Clubs, used the Lamborghini on a couple of occasions to promote the company and one of its corporate partners. Basically just like all those yachts and jets that you saw in the other videos. And that's especially true given how many people at G Clubs knew of the purchase of the Lamborghini. I mean, what was Mr. Guo going to do, steal it from under all of their noses? What happens if somebody from G Clubs called up and said, hey, one of the members wants to drive it? Where is it? What were they going to say? And that's especially true when you think about Ms. Reyes's testimony about the Lamborghini. Here it is. Please revisit it when you're deliberating. Because it really kind of sums up why the government's case on this doesn't make sense. So during cross-examination, Ms. Reyes testified that she saw the Lamborghini video in 2022, and it was a video in which Mr. Guo was promoting G Clubs. She couldn't remember one. But you remember it was a bit of a funny moment during testimony. She corrected me. I said he was driving the vehicle, and she said, no, he was showcasing it. Now, the notable thing is that she said that when she saw him showcasing the Lamborghini, she wasn't concerned about, oh, no, Mr. Guo has stolen the car, why does he have it? Her concern was that he's promoting it as a benefit to G Club's members when the car wasn't available yet. So think about that. Ms. Reyes, the CEO of G Clubs, didn't freak out because she saw the car in Mr. Guo's Connecticut home. That didn't bother her because she knew that that was part of Mr. Guo's job as a spokesperson for the company. What bothered her was he was telling members about it before it was ready. The government's own witness, Ms. Reyes, offers you the most credible evidence on why Mr. Guo had that car at his home. And that evidence supports Mr. Guo's version of events, not the government's. Now, Ms. Reyes's testimony also explains the government's other big evidence. You heard Mr. Finkel talk about it. The fact that the name on the paperwork related to the car was found in the Connecticut home. And it was in the name of Chow Defeng, Wayne, Mr. Guo's daughter's boyfriend. But you also heard an explanation of that from both Ms. Reyes and Scott Barnett. Remember what Ms. Reyes told you? After they bought those cars there was some issue with insuring them, right? Now, there is no evidence anywhere that Mr. Guo was involved in any of these insurance issues. This was a G Club's issue that they were trying to resolve to get these cars to the members. And you even heard that G Clubs hired a firm to do that in 2022. And what was the nature of that firm? A firm to work with future benefits of renting for members, yes. But it wasn't working. So now think about what Mr. Barnett told you. Remember him, the former NYPD detective. Now turned head of Mr. Guo's security team at the time, one of Ms. Maestrello's handymen, I guess. Well, he told you that there were G Club's motorcycles in his name that Yvette Wong was going to rent out to members. The same with the Lamborghini. And that was because Mr. Barnett had a license. Nothing nefarious. Nothing about holding it for Mr. Guo. But he had a license. But Barnett got spooked at the prospect of members leasing out or renting out the car, or the motorcycle, excuse me. Why? Not because he thought it was illegal. He didn't want somebody to crash a $40,000 motorcycle into a lamppost and make it his fault. And you heard that the Lambo was the same. Mr. Barnett understood that they were going to rent that out to members as well. So now you've heard both from Ms. Reyes, a government witness, and Mr. Barnett, a defense witness, the same thing, that they were going to rent this car out. That they were going to rent these motorcycles out, even though they were in Mr. Barnett's name. So why do you think it would be any different with Mr. Defeng? They put the names in people they trust. And do you think Mr. Barnett, a longtime NYPD officer, would sign on for it if he thought it was criminal? He's not a member of Mr. Guo's family. He's not a supporter. So why would he do it? So that's the cars and the motorcycles and the campers. All the other evidence is much less compelling. The Bugatti. What did they show you? They showed you that the name on the paperwork was originally Milesun Guo. Ms. Reyes explained that. She told you that Milesun Guo had an in with Bugatti, so he introduced it. So his name ended up on the paper. And then she fixed it. It was a typo. What about the Ferrari? Well, Milesun Guo is clearly a pretty well-connected Ferrari driver. So the evidence is he helped his friend pick out a Ferrari, and that he test drove it once. Or where Mr. Finkel told you whether all these things were paid for by loans and there was no loan repayments. Well, look at the bank records. Take a look at money coming back from G Clubs International Limited. Back to the Puerto Rico entity in 2022, when the loans would be repaid. Look, there's a withdrawal for almost $5 million. So think about that. Have they shown you the whole story? So what does that bring us to? That brings us to the Crocker Mansion, Darlington. The place that the government claims G Clubs bought to be Mr. Guo's New Jersey estate. So here's what's undisputed. Right. After a considerable struggle with Mr. Khaled at Crane, what happens? Mr. J.E. suggests that because there's nowhere else for the money to go, it should be transferred to the hedge fund Hamilton, right? Now, that wasn't Mr. Guo's instruction. That came from Mr. J.E. Mr. Guo said, send it back. But in the end, you heard Mr. Khaled refused to do that. So the only viable solution was sending it to Hamilton, which was approved by Mr. He, by the way. So the money is transferred to Hamilton, and Hamilton uses it to buy a property, an investment property, in New Jersey. Now, the government claims that he did that for Mr. Guo. But there's no evidence why Mr. J.E. would take this money out of his fund, where he's earning a fee on it, and use it to buy a third home in the States for Mr. Guo. And there's no evidence of why Mr. Guo would even want that. And I don't mean any offense here, I'm from a small town myself. But here's what the government would have you believe, that this Chinese billionaire, just a few years removed from living an insane life in Beijing, with access to a yacht, a private jet, hundreds of millions of dollars, that what this guy really is dreaming for is a huge house in Bergen County, New Jersey. He has an entire floor of a luxury apartment in Manhattan. And just in case that's not good enough, a home in Connecticut with tennis courts. And this guy says, no, I want another place off the turnpike. That's what he wants you to believe, that they would steal all this money, this man, who could be anywhere in the world in any second, and says, let me steal this money to complete the triple crown of the tri-state luxury home circuit. It doesn't make sense. What makes sense is that Mr. J.E. bought it to be the kind of physical club that G Clubs had promised its members. A safe space. That's what makes sense. And when you think about it and when you look about it, it's consistent with the kinds of properties that Ms. Reyes was looking at in London. This is one of them. This is another. Don't they look familiar? They look a lot like Mawa. They have spas. They have all the same kind of things that Mawa has, because that's what they were looking for. So you can see that the actual place, the property, is very similar to what G Clubs was already looking for. So doesn't it make sense that the hedge fund manager managing G Clubs' money might buy a place like that? So what are they going to say? Well, Ms. Reyes didn't know about it. Well, the reason why she didn't know about it, it's because it was invested in a hedge fund. And as you saw time and time again, an investment in a hedge fund, the hedge fund manager decides what to invest in. That happened with Yield Esta and Bo Collins. And it happened with Heyman. It's no more nefarious than when it happens with Mr. J.E. So it's no shock that Ms. Reyes wasn't tracking the company's investments because she wasn't even responsible for the company's finances. Maybe they'll say, but the slide says it's in Puerto Rico, that's where it's supposed to be. There are no G Clubs members in Puerto Rico. You know where there's a lot of G Clubs members? In New York. You know what else there is? A large international airport where G Clubs members can fly in to use the club. Again. That makes sense. Okay. So why was he picking out the furniture? Why wouldn't somebody from G Clubs be doing that? What did Ms. Reyes tell you? Mr. Guo was a trendsetter for that community. G Club's members liked his taste. What did Mr. Guo do in China? You heard from Ms. Maestrello, he built luxury hotels. He built properties. He had a huge hotel called the Pangu. And what kind of designers were they looking for? You saw this in the text. So if you're trying to decorate a luxury clubhouse for people who have similar taste to Mr. Guo, then doesn't it make sense for Mr. Guo, the company spokesperson and resident luxury hotel designer, to weigh in on the design? And I know they showed you all those things about mattresses and toilets and all those different invoices. Those are all things that you would have in a luxury hotel, all things you would have in a luxury clubhouse. It's the same thing. So what else does the government have? It has the testimony from Christine Frosini, the real estate agent, and those documents where it says, where Mr. Guo says the house is for his family. Or those invoices about the ladies' wing or the madam's room or Wayne's room. But I know there was a lot of emphasis placed on that. But emphasis is not evidence, ladies and gentlemen. So what does the evidence tell you? But first, it tells you that the Malwa property was part of an exclusive neighborhood. And that it was designated to be used as a home, right? Ms. Frosini told you that. On the other hand, as we've seen, Malwa looks like a pretty ideal G Club's clubhouse, right? It matches what's in the brochure and it's a great location. And G Club's members were clamoring for their benefits. Right? One hitch, do you think you could buy a place like Malwa if you say, hey there, we're looking to buy this mansion for our anti-CCP, pro-Chinese democracy social club. We're going to bring in a bunch of people from all over the world and have a ton of security. Because the Chinese government might try to kidnap our members. Do you think there's any universe in which you could buy a house like that, anywhere in the country? Of course not. So, yes, they said the Chinese billionaire was going to buy it. Because that's the only way they would ever be able to pull it off. And Mr. Finkel said that the reason why there was so much secrecy was not because of their concerns of the CCP, but because of the trustee and the bankruptcy. That doesn't make sense. Because they bought the house and put in all that secrecy before the PAC's judgment and before the bankruptcy filing. Malwa was bought in November of 2021. The PAC's judgment happened in February 2022. The bankruptcy happened in February 2022. It doesn't make sense. So that's the government's proof. Does it move the needle? I submit it doesn't. But it certainly doesn't when you heard from Mr. Barnett and Leanne Lee. And Mr. Barnett told you that he, who was the head of security, he used to take Mr. Guo there from time to time. They didn't put forth any evidence of Mr. Guo even visiting Malwa or staying in Malwa, excuse me. We gave you that. And Mr. Barnett told you why. He went to oversee the renovations, he went to broadcast. And you saw this footage of him broadcasting, right? That's what he was using the property for. But Mr. Barnett is Mr. Guo's head of security, right? His job is to make sure that Mr. Guo is safe. And as part of that, he's got to know where Mr. Guo is and where Mr. Guo is going to live. And he never understood Malwa to be Mr. Guo's place. He never understood that. In fact, he thought it was supposed to be a place for the movement members to enjoy, like those that bought G Club's memberships. And in fact, Mr. Barnett's impression was that Mr. Guo's wife hated the place and didn't want to live there. Okay. So why were there clothes in Malwa? Well, Mr. Barnett also told you that he made the call to have certain members of the family, Mr. Guo's daughter and wife, go to Malwa for a little bit in 2023 because of security concerns. So is it any wonder that they kept some clothes or cash or documents there? These are people who may very well have to flee at a moment's notice because the CCP could try to disappear them. And finally, there's Lian Li's testimony. She puts the nail in the coffin. Because what did she tell you? She tells you long before an arrest, long before there was any need to explain what Malwa was. She talked about it with Mr. Guo. And Mr. Guo told her to go find other properties for people in the movement to use. And before they bought Malwa, he asked her to put together a presentation about the property so that they could explain it to the movement members. So they could highlight and showcase what they were going to use it for. That's how you know what Mr. Guo was thinking about the property. That was before he was arrested. That was before they charged him for buying the Malwa place. So think about it. That's what you know. And against that backdrop, how can you say that the government has proven its G Club charges beyond a reasonable doubt? You cannot. So we come to the Himalaya exchange. And I'm going to try not to spend a lot of time on this. Because they didn't. Because, frankly, it has very little to do with Mr. Guo. You didn't see any evidence he owned it. You didn't see any evidence he was directing its operations. The most you saw is that some unnamed Himalaya exchange employee told Jesse Brown Mr. Guo wanted to start on a certain date. Well, I think, as you've seen over the course of this trial, Mr. Guo is very eager for things to happen for the movement. And the exchange was a critical part of that. Because it was intended to help people who feared the Chinese government move their money easily. That was the idea. And you heard from Ms. Sklar that cryptocurrencies are a prime way to deal with repressive regimes. And you heard from Mr. Doran how the Chinese government tends to confiscate property. But that's all you really heard about Mr. Guo's role at the exchange. So what does the government say he did wrong? They said he promoted it improperly. They said it's not a real cryptocurrency because there were credits and not a lot of activity on the blockchain. I'm going to submit to you that you do not have to spend a lot of time on this argument because you have testimony from Ms. Sklar, who is the only cryptocurrency expert that you heard from at this trial. And what did she tell you? She told you that the Himalaya exchange worked like a centralized cryptocurrency exchange. And you heard that a centralized cryptocurrency exchange, like well-known ones like you may know, like Coinbase. It's common not to have a lot of transactions appear in the blockchain because of the way they are set up. Instead, because of that, all of the trading is reflected on an internal company ledger. That's where you get the credits right from. There's nothing unusual about that. Basically, what the government is asking you to do is to convict Mr. Guo based on a philosophical difference in the cryptocurrency community. That is not evidence beyond a reasonable doubt. And it wasn't like the exchange was hiding any of that. You saw that the exchange openly discussed in its white papers the use of credits. And they had Mr. Roberts, the investigator. What did he tell you? He just assumed that couldn't be true. But then look, sorry. He just assumed that the idea of back-to-back redemptions, the one-to-one redemptions, couldn't be true. But look at what he said on cross-examination. He said that he actually couldn't know how much HDO was in circulation. So he couldn't do it. And why was that important? Because what the exchange actually said was the one-to-one backing was for HDO in circulation. And he didn't know what was in circulation. So you can discount his testimony on that entirely. You saw that Armanino, an auditing firm, actually had access to the information that Mr. Roberts admitted he didn't have. And it concluded that, in fact, there was a one-to-one backing between the number of HDO that customers had actually bought and what dollars the exchange were holding in reserve. So, again, much ado about nothing. And then there's the gold. I think we can all acknowledge that Mr. Guo's statements on the gold may seem a little confusing. But that's not surprising. Because you heard from Mr. Brown. The folks at the exchange knew he wasn't explaining it right, but they decided not to tell him. And that's not the only time that Mr. J.E. kept information about the exchange from Mr. Guo. You remember Lian Li's testimony about how she traveled to London to try to get financial records because Mr. Guo was concerned about how Mr. J.E. was running the exchange. And what did Mr. J.E. do? Stonewalled her. So does that sound like Mr. Guo is controlling Mr. J.E. and the exchange? But anyway, what's the government's proof that Mr. Guo was intentionally lying about the gold? The Armanino report. Ms. Sklar's testimony, only half the story. Mr. Brown told you that there were plans to purchase gold. So you know that's not something that was made up whole cloth by Mr. Guo. And you see at the end there. Mr. Brown says he doesn't know what Sharps Pixley is, do you see that? You know who does know what Sharps Pixley is? Tom Bishop. Tom Bishop, who described to you how, in March of 2022, the Himalaya Exchange sent $5 million to Sharps Pixley, a London-based gold broker. So the exchange was making good on its gold promise, just bit by bit. And you don't spend $5 million like that if it's a fraud. Jesse Brown told you this was a real business. He told you about all the compliance. In fact, he told you he thought the company had too much compliance in place. He told you that Mr. J.E. had spent millions of his own money before any tokens were sold. And if this were all a big fraud, would you just give $70 million in redemptions to the exchange customers back if you're just trying to steal the money anyway? I mean, those are redemptions that the exchange wasn't obligated to honor. It doesn't add up. And finally, you have the loan, the $37 million loan. I don't understand what's wrong with the loan, frankly. The money came from the exchange's profits. They were open about it. It was approved by the exchange's board, including Jesse Brown. And it was filed with a U.S. court. If anybody thought they were doing something illegal with that loan, why would they be so open about it? Why would Mr. J.E. talk to Bo Collins about it? Why would they make no effort to hide it? So now there's one last so-called misrepresentation that we have to talk about. The government spent some time on this. And that's the so-called guarantee that Mr. Guo made to pay everyone back for their losses. Remember, they ended their case with that spliced together video of Mr. Guo saying he would pay people back. So a couple of things on that. The first is, remember, even if you find that there was a misrepresentation, you have to find that it was material. That it would be expected to be of concern to a reasonable and prudent person in making their decision. And what was the government's evidence? They put some people up who said they relied on these guarantees and they thought it was no risk. Judge Torres also instructed you, however, that you have to consider the total mix of information available. And what other information was available then? Well, you saw Mr. Guo tell people in the announcement video that GTV was risky. That they should read the prospectus and understand its risk. And the prospectus included disclosures about the risk. It also told them that it was risky. And you saw that Mr. Guo was public about his bankruptcy. He made a video about it and told people about it. So all of that is part of the mix of information. And you also heard from Mr. Dragon about how he, a valuation expert, would think about the impact of the guarantee on assessing the investment opportunity. What did he tell you? He told you that he would have to consider a guarantee. But there's a number of factors that go into how you decide to weigh it. Here's what he says. So measure this up against what Mr. Guo said. And I think you'll see that Mr. Guo's statements are hardly the kind of material ironclad guarantee that the government makes them out to be. And think about this, what are the losses he's supposed to pay back? On GTV, you saw Mr. Guo's view. He thinks Soraka ate the loss. He thinks the loss came from Soraka as part of the pizza, right? So why would he pay back someone else? And how could there be any losses on the farm loans? When the loans didn't even come due until after Mr. Guo's arrest? And G clubs, how can there be a loss? People paid for those memberships. And each of the government's so-called victim witnesses failed to submit refund requests during periods set by the company. Not Mr. Guo. Mr. Guo didn't deny them those refunds. And finally, the exchange. Their witnesses bought these coins at 10 cents apiece. And is there any evidence that the price dipped below 10? So what is the loss? And here's the thing, Judge Torres instructed you that the government has to show that at the time Mr. Guo made the statement, he knew it was false. It's not enough that the statement he said later turned out to be untrue. But all the government has given you is that Mr. Guo supposedly didn't make these repayments that he was owed. They've showed you nothing about his intent at the time he made those statements. And that is not enough. So I've nearly come to the end of my time, and I just want to leave you with a few closing thoughts. As you know, when I sit down, Ms. Murray will have a chance to reply. The government has the burden, so they get the last word. But I submit, even with that advantage, they still will not be able to sustain their burden. And so what does Mr. Guo get? What helps balance the scales? Well, one thing he gets is the presumption of innocence and the reasonable doubt standard. As we discussed, from day one of this trial through right now, Mr. Guo must be presumed innocent. And he will always have that presumption of innocence unless you find that the government has proven his guilt beyond a reasonable doubt. And what does that mean? Judge Torres told you. It means that after you review the evidence, you must find Mr. Guo not guilty if you have the kind of doubt that would give you serious pause in acting on serious matters in your life. How serious is this? And so I just want to say something about the quality of the evidence that the prosecution has given you. Don't worry. I'm not going to go through it all again, I promised you that I was going to sit down. But just think about some of what you've seen and heard at this trial. And ask yourself whether you can actually have confidence in the government's case. They called a lot of witnesses. And Judge Torres gave you guidance on how to evaluate the credibility of witnesses. Look at how they answered questions on direct and cross-examination, right? Are they different? Do they have an incentive to favor one party or the other? And obviously, your common sense. So one class of witnesses they gave you are people who will tell you the inside story. According to them, Limari Reyes or Haitham Khaled, Jesse Braun, Yali. All people here intimately involved with what happened. The CEO of G Clubs, the CEO of the exchange. The head of banking relationships, a member of the Iron Blood Group. All people intimately involved in things that they say are frauds. Who took actions in furtherance of the things that they say are frauds. But you saw them in this courtroom at that witness stand, not the defense table. And why is that? Because the government agreed not to prosecute them. And the price for the government's mercy? That they testify. If asked by the government, and they tell the truth, they told you. What else did they tell you? That they only get to keep the deal if the government thinks they are telling the truth, right? So is it any wonder that they would say things that they think are helpful to the government? Oh. I never heard of Mawa. Miles Guo controlled G Clubs. I did nothing at the exchange. And the thing is you saw no evidence corroborating any of those things. Just the words of witnesses relying on the government for their get-out-of-jail-free card. That's it. Now. The government also called all of those so-called victims, right? Now. Ask yourself this, if someone who is close to you had a serious medical issue, and Yali or Lu Zhou was the doctor. How comfortable would you feel? Would their involvement give you pause? Because that's what you have to think about here. And think about the way those witnesses were on direct examination. More than happy to answer any question. And what was their answer to almost every one of those questions? Miles Guo told me to do it. I did it because of Miles Guo. Miles Guo said there was laser technology. Did you ever see that in a video? But then on cross-examination, right, just think about Yali. Just the steady string of I don't remembers, I don't know, I have no idea. Or Ms. Chen on cross-examination. How she just wouldn't answer the question. But instead took every chance she had to go out of her way to call Mr. Guo a fraud. Same with Jenny Li or Lu Zhou. Or think about Patrick Chin, who was so confused that he thought he had invested in Guo Media. Even they don't say anybody invested in Guo Media. And just think about this, each of those witnesses testified that they followed Mr. Guo blindly. Except when he told them to look at the documents that would undercut the government's case. That's the one time they didn't follow his command, according to them. Does that make sense? They did everything this man said except that. I guess, but the truth is a foreign language to those witnesses. So ask yourself, why did they testify this way? Well, Ms. Murray, I'm sure, will say they are angry. They think they've been scammed, they think they've been defrauded, they want their money back. But think about that for a second. Many of them told you they didn't wake up until they saw the government's indictment in this case. An indictment is just an allegation. And basically, these witnesses, even under the government's version, just took the government's word for it. They swallowed the government's tail hook, line, and sinker. Without hearing the evidence that you've heard. So they have an obvious bias towards the prosecution. At the bare minimum, they are looking to them to get money back. And at least one of them, Yali, told you about how the Chinese government visited her parents and told them that she needed to knock it off. To cut her association with Mr. Guo. So is it so hard to believe in a case like this that she might take that stand and testify in a way that she thinks that the CCP would approve of? To disavow Mr. Guo? Of course not.
Continued on next page.
Mr. Kumraju said, and then they gave you all those summary charts, so many charts. But no matter how many there are, their value to you is zero because they're all misleading. You remember Mr. Medrano's chart? That was the one with the Steve Bannon clip. I won't pull that back up, or Ms. Espinosa's chart. Remember that's the one where she testified about a dozen slide chart with hundreds of arrows. Only to have Mr. Skirik draw the same transaction fairly and accurately according to Ms. Espinosa on a piece of paper in 2 minutes. Or the G Club's chart witness who put up a chart of G Club's loan agreements that counted both signed loan agreements and earlier drafts. Why do that? Just to make the numbers look bigger. Or Mr. Hinton who we talked about. Remember how Brattle worked on the chart for like a year. And the prosecutors were changing it until the day before he testified. And how those boxes didn't make any logical sense. Look at those. Under Mr. Hinton's testimony. These arrows don't make any sense. Think about it. How he told you that you couldn't do the analysis necessary to tie the farm loan money to any of these payments. That's a more accurate chart. So how much faith can you have in these charts or this testimony when you see this? They also put up a lot of documents. One of the documents Mr. Finkel talked about was an unsigned trust agreement. Do you remember that, between Milesun Guo and Himalaya Exchange? And he said, well, look, it's the execution version. But it wasn't signed and it wasn't dated. So how much faith can you have in that? Can you have any idea when the document was created? Why it was created? Who created it? Whether it was an idea that was considered and rejected, whether the author had any accurate information? Of course not. You have no information about the creation of that document. And I'm sure Ms. Murray will stand up and say, well, it's all part of the cover story. Well, Mr. Ferguson asks you to use your common sense. And ask yourself this in your common sense. If it is part of the cover story, why wouldn't you sign it? why wouldn't you finalize it? What good is the document to a cover story as unsigned? It doesn't make any sense. I'm sure they'll talk about videos. When I sit down, I'm sure you will hear a lot about videos. I'm not going to go through them all. There's one that you saw during the trial that Mr. Finkel talked about that's instructive. And that's the one where Mr. Guo says that the US government will never falsely accuse you of a crime. You remember that one? They showed you that near the end of trial. Well, just in case it's not clear. Mr. Guo's opinion on that has changed. But, think about the clip for a second. It actually undercuts the government's case. Think about it. Mr. Guo made that statement during an SEC/FBI investigation into all of the stuff that you heard about. Ask yourself. Mr. Guo, the criminal mastermind with access to a yacht, a jet, and hundreds of millions of dollars in fraud proceeds according to them, just sits here in New York waiting to be arrested when he knows that people are making complaints to the SEC and the FBI. That makes no sense. Or how they show you all these scary bank account charts and say innocent people don't act like that. Only people with something to hide, asking you to ignore the obvious. The reason why Mr. Guo and his compatriots were doing any of those things was because they were being hunted by the CCP. Not the FBI. Think about the video again. He's inviting the FBI into the tent, not running away from them. But he's terrified that the CCP is chasing him, and he has good reason to be afraid, given the lengths they've gone to stop him. You know what, you heard from Mr. Doran that those steps, multiple cell phones, different bank accounts, heightened security, that's the advice that Mr. Doran gives his clients that are targets of Operation Fox Hunt. And there's the biggest Operation Fox Hunt target maybe in the world sitting right there. So that is the kind of evidence that they've given you. That is the shaky evidence that they want you to use to find this man guilty. But is that the kind of evidence you can rely on to do so? I say you can't. Every time I've done this in the past. Whenever I sit down I always remember a bunch of things I should have said, and Ms. Murray may hit on some of those. And when she does I want you to think, what was Mr. Kumraju say to that? How would we the defense team respond? And if you do, I think you'll see that they still can't meet their burden. What else does Mr. Guo get on his side of the scale? Well, he gets us, his lawyers, and so here I am slugging away. And what else? Well, Mr. Finkel talked about it. He talked about how in this country, we have you. And that's specially true for Mr. Guo, because you are to be a jury of his peers, to determine his innocence. He gets you reviewing the evidence, looking at all the angles. He gets you using your common sense and asking does it make any sense. He gets you applying the critical eye to the government's proof that is required by law. And he gets you using your best judgment to decide this case. He gets you. And, ladies and gentlemen, I have to say, if you do all those things, apply the law that Judge Torres has given you to the facts that you've heard during this trial, there is only one verdict that you could reach that's consistent with justice, and that's that you send this man home. That you send him back to his family, that you send him back to his friends, that you send him back to his fight. Thank you.
The court said, "Members of the jury, we still have not finished all phases of the trial. Next is going to be the rebuttal by the prosecution. After that, I will be giving you more instructions on the law. Briefly, but at this time we're going to take a break of about 10 minutes. Remember that you're not allowed to discuss the case amongst yourselves. Don't permit others to discuss it in your presence. Don't read, watch or listen to anything from any source that touches upon the subject matter of this trial."
The law clerk said, "Jury exiting."
Jury not present.
The court said, "Who will be delivering the rebuttal?"
Ms. Murray said, "I will, Your Honor."
The court said, "Please let me know when you're ready."
Ms. Murray said, "Thank you."
Recess.
The court said, "Please get the jurors."
The law clerk said, "Jury entering."
Jury present.
The court said, "Please be seated. Members of the jury, We will now hear the government's rebuttal by Assistant United States Attorney Juliana Murray.
Ms. Murray said, "Ladies and gentlemen, you've heard this before, and it's true. The government is the only party with the burden in this case. We have to prove the charges beyond a reasonable doubt. Now that's the very same burden of proof that is applied in criminal cases every single day in every single courtroom in this country. We've embraced that burden, and we've met that burden. But when the defense chooses to make arguments, it's your duty to scrutinize them, to examine whether they line up with the evidence, with the testimony that you've heard during this trial. And they don't. Now, each fraud scheme that is charged proves Miles Guo's intent as to the next fraud scheme. And collectively, they prove that Miles Guo is guilty of the conspiracy charges in counts 1 through 4. The questions on counts 1 through 4, the conspiracy charges, are merely whether Guo had an agreement with anyone to commit certain crimes: wire fraud, bank fraud, money laundering, securities fraud, and racketeering. That's just whether he agreed to do that. And of course, he at least agreed to commit those crimes. You can judge this based on his actions and the actions of his co-conspirators alone. Now, counts 5 through 12. Those are the substantive counts. They ask you to look at whether Guo committed or aided and abetted the private placement, the farm loan program, G clubs, and the Himalaya exchange. Then whether Guo used or aided and abetted the use of $100 million worth of fraud money to invest in Haman. And you've seen the evidence. You know that he did all of those things. You know that he is guilty of all of those crimes. Now I'm not going to address all of the arguments that Mr. Kumraju made, because frankly I don't need to. Mr. Kumraju spoke with you a lot yesterday about connecting the dots in this case. The dots are all of the evidence that you've seen and heard during this trial. They include the witness testimony, the emails, and loan agreements and bank records and other documents, and the dozens of defendants' video broadcasts. And a lot of the defense argument were distractions. Efforts to make you forget about the crushing evidence of Miles Guo's guilt. To make you forget about the dozens of entities that made up Miles Guo's enterprise. To forget about the complicated web of hundreds of bank accounts in the US, and in places like the BVI, the UK, Switzerland, Abu Dhabi, and Kyrgyzstan. To forget about the large money transfers, sometimes 2 or 3 different bank accounts in a single day, that were done to conceal the true source and purpose of Guo's fraud proceeds. To forget about the sham loan agreement, the consulting agreements, and the other documents that were created simply to paper those transactions to make them appear to be legitimate. To forget about the hours and hours of video of Guo broadcasting to his followers, promoting himself and his enterprise, telling his followers how he would make them rich, how they could never lose money with him, how he guaranteed it. Forget about the victims that you heard about. These are people who were followers of Miles Guo. They watched those videos. They invested their hard-earned money in his investment opportunities. Why? Because they trusted him. They want you to forget how this man, Miles Guo, the man that they believed in, robbed them. They want you to forget the evidence because it proves that Miles Guo is guilty. Now, the defense spent much of its energy during this trial focused on Guo's political activism. Is Miles Guo a real political activist or not? I don't know. I don't care, and neither should you. Because that's not what this trial is about. Miles Guo's true stance on the CCP. It's not a question that's being asked of you in this case. The question is whether he intended to commit fraud. And he did. In a valiant effort to confuse the issues before you, Mr. Kumraju then said, "There's no evidence that Miles Guo ever took a penny to attempt to undermine the political movement. So the government hasn't met its burden." He argued that Guo would never intentionally harm the movement. The movement that he built by stealing money from supporters. And Mr. Kumraju said, he can't have had the required criminal intent. Now, it's true. You cannot take the whistleblower movement and the NFSC out of this case about Guo's criminal fraud enterprise. They have featured prominently in the evidence that you've seen and heard. And you know now that you've seen all the evidence that that is by design, Guo's design. Because that's how Guo's criminal enterprise worked. All of these investment opportunities. They were offered to members of the whistleblower movement in the NFSC, Guo's followers. Why? Because Guo preyed on a community of individuals who shared in the anti-CCP view. They were, as Mr. Kumraju himself stated yesterday, Guo's target audience. Did Guo's marketing to this group necessarily exclude a broader set of potential investors? Of course. But that wasn't bad business sense. That was Guo's plan. He preyed on the pliable followers who believed the messages he espoused in his hours of broadcast. People who would be willing to volunteer their time, transcribing and translating his videos. At the expense of their personal lives. All while collecting whatever money he could from them because they believed that he would take care of them. They believed they would get huge returns on their investments, and they believed that if they suffered losses, he would repay them. They believed that because that's what he told them time and time again. And when people complained that they were not getting what they were promised, stocks, profits, benefits, cryptocurrency, Miles Guo turned against them. He branded them CCP spies. And he outed them to the sprawling and fiercely loyal whistleblower movement. The defense wants you to believe that Guo could never possibly have the criminal intent to take money from his followers by lying. The defense is correct about one thing: Guo loved the movement. And at least one of the reasons that he loved it was because it was his personal piggy bank. Now I'm going to walk you through just a few of the defense distractions that you heard yesterday and today. You heard some arguments yesterday from Mr. Kumraju about the GTV private placement. I'm not going to talk to you about pizza and soda like Mr. Kumraju did. I'm going to talk about the evidence. First, defense counsel argued that Guo did not commit fraud because he did not lie about what the GTV private placement money would be used for. That's incorrect. Guo said in the April 20, 2020 launch video that the money would be used for GTV. He did not say it would be invested in a hedge fund. So that was a lie. But in any event, Mr. Kumraju completely ignored what Guo said to the old chairs like Wei Chin, who you heard testimony from during this trial. He told them that there was no risk to GTV. That the investment money was guaranteed. Defense counsel completely left out that Guo made this very same promise again on June 2, 2020. The day that the private placement closed, and that was recorded. That's in Government Exhibit Z9 on page 8. It's up on your screens here, June 2, 2020 in Guo's broadcast. In this GTV investment, I had a separate conversation with each investor. This is a serious and solemn commitment and responsibility of Wengue Guo to you to be responsible for this investment forever. This is a legally valid commitment, an attitude. He's acknowledging what he told the old chairs. That there was no risk in the investment. None. That he would be responsible. Was he responsible? No. GTV and Soraka lost investors' money they still haven't paid back till this day, more than $30 million. So, yes, Guo lied. He lied about what the money was for, and he lied that the investment was guaranteed. He said there was no risk. Next, counsel argued that in any event it was fine for Guo to invest in the Heyman Fund because that $100 million. That was Soraka's money. It wasn't investor money. First of all, that's factually inaccurate. The Soraka investment came from the JP Morgan 5601 account. That's where the investor money for the GTV private placement was sent. That's the source of the Heyman investment. It's not Soraka's money. It's supporters' money. It's victim money. And even Miles Guo acknowledged this. Again. Government Exhibit Z9, page 6, Guo boasted about the success of the private placement. He said they had an initial valuation of $200 million. But instead it exceeded the highest expectation and raised $350 million, $350 million received. Which is just for the contracts with GTV. That means that the entire $350 million that was raised through the GTV private placement. It was all for investment into GTV. There wasn't some special secret overflow of $150 million that magically belonged to Soraka and not GTV. And Soraka wasn't able to use a portion of the GTV money however it wanted because the investors who sent that $350 million, they all sent it to get the GTV stocks that Guo promised them. So next defense counsel says, well, the investment in Heyman was totally fine because Miles Guo thinks that's how to take down the CCP. What? Does that make any sense to you? A $100 million investment in a Texas hedge fund can destroy a global superpower that has an economy in the trillions of dollars? Does the hedge fund have anything remotely to do with taking down the CCP? Of course not. You heard from Ms. Schottenheimer. It's an extremely high-risk bet on what might happen and what never happened with the Hong Kong dollar pay. And Guo's statements to Kyle Bass in the 2018 interview, they don't say anything different. Guo did not say and Bass didn't say either, hey, you know, we both hate the CCP, one way to take them down. Invest in my hedge fund. They never say that because it's nonsense. And by the way, there's no way. No way that Guo thought investing in the Heyman fund was a way to take down the CCP. Do you want to know why? Because if he thought it was, he would have bragged about it on his broadcasts. He would have told his fellow freedom fighters, great news, we invested your money in the Heyman fund. It's a bet that will take down the CCP. That's not what he says at all. Look at what he did say. He covered it up. He told the fighters that nothing bad happened. He didn't mention anything about trying to fight the CCP with the Heyman bet because he wasn't. You know exactly what he was doing with that $100 million investment. He was trying to make money for himself and his family. Third, defense counsel argues that if the Heyman investment was hidden, they wouldn't have been so brazen about it. But they did hide it. They did the internal transfer from the 5601 account to the 2038 account. They did that for the purpose of concealing that the source of the funds in the original account was GTV investors. There's no reason to do that internal transfer other than to hide the funds. And William J.E. asked Steele Schottenheimer, hey, can we send the money from a different company? When she said no you can't. What did they do? They opened that second account. The account that was used for the express purpose of that internal transfer. The account that was used to clean the money before it was sent on to Heyman. And Mr. Kumraju mentioned yesterday the document that was submitted to Heyman in connection with the investment. And he said, well, they disclosed on that document that the source of the money, the $100 million, was the sale of the shares of the subsidiary. What Mr. Kumraju didn't show you was other evidence in this case. This was the original investor profile that was submitted with the Heyman investment. There is no description of source of wealth here. It's only when they go back with their new clean bank account that they provide this explanation. The explanation that you saw on the right here, selling shares of subsidiary. And by the way, there's nothing unusual or strange about William J.E. being the primary contact for Heyman. Mr. Kumraju mentioned that yesterday. He said it wasn't Miles Guo. It was the moneyman William J.E. That's how Guo works. You know that. He used agents. He had other people deal with paperwork for him. That's to be expected. And Steele Schottenheimer told you, this is often how it works with wealthy family offices. Let's talk about the movement again. The companies that Guo used to collect money from his victims, they're just that. Companies, businesses, entities with supposed commercial purposes. Like the G Club membership company and the Himalaya cryptocurrency platform. And when it benefited him, Guo himself put distance between those entities and the movement. We talked about this a bit yesterday. This is June 28, 2020. A broadcast. He says, the NFSC, please remember in the future. It's a quasi-political entity. That's the entity affiliated with the movement. Then he says that G-Series, GTV, G Fashion G Clubs. G Coin and G Dollar have no substantial connection with the NFSC. It's like an NGO. But the G series are completely commercial institutions, including the Himalaya Farms. In that same broadcast he says, "To the brothers in arms who wanted to donate to the Himalaya Farm, let me say this once again. Any Himalaya farm that accepted donations will all be disqualified. You can invest, but you cannot donate. Our whistleblower movement does not tolerate the asking for money." Later he says, "This is completely a business operation. Do not link the G series under any circumstances, to the NFSC. That is all bullshit." Those are Miles Guo's words distancing the political movement from the businesses. And by the way, all of Guo's schemes, the six that AUSA Finkel went through yesterday, the rule of law, GTV, the farm loan program, G Club, the Himalaya Exchange and A10, those 6 schemes. As well as the others that you heard about, H Coin Lockup, G Bank, G Dollar, they tell you something. Something important about Guo's modus operandi. This is what he does. He was not paid by any of these businesses. By these companies, and they were businesses. They were not political organizations. So if he's not being paid, why is he doing this? It's for the fraud money. He doesn't have a job. He doesn't clock in and clock out somewhere every day. He spends his days making broadcasts that pitch these business opportunities. All similar opportunities with grand promises of high returns, stock, and the assurance of getting rich quick. He repeats those promises over and over again. He promises to guarantee the investments. And you know those are all lies. Now yesterday Mr. Kumraju told you that Miles Guo didn't commit fraud by promising stocks for G Club because G Club didn't give stock until sometime in the future. It was a generalized promise. So Mr. Kumraju said investors could not reasonably expected stock in exchange for their G Club membership payments. You know what Miles Guo said. You know how he raised money through G Club. August 7, 2020, he says, "In the past I said, if you buy G Club, you will have G Fashion stocks." It's not the first time that he said that. He repeated that over and over again. He promised stock in exchange for G Club membership payment. And you heard that from the victims who bought G Club membership. They expected stock. That's what they were promised. Now in the same broadcast as he often does, he tries to walk it back. He says, "We shouldn't even be talking about stocks. It's a problem if we use that word, stock. And you know why that is. It's on the do not say list. The list of things that Miles Guo is not supposed to say in his broadcast because they can get him into trouble. Because those are the things that he says when he lies to steal people's money. But he slips up sometimes. And that's exactly what he's done with G Club. He told everyone that they could get stock. And that's what they expected. By the way, despite what the defense wants you to believe and what they mentioned today a number of times, the G Club fraud. It's not MAWA. It's not the Lamborghini that was in Miles Guo's garage in Connecticut. The G Club fraud, plain and simple, is Guo's repeated promise that members would get stock that never existed. And he brought in hundreds of millions of dollars through G Clubs based on those lies about stock. That is the G Club scheme. That is the crime. So next, the farm loan programs. The farm loans were designed to paper the stock investments after the SEC started investigating GTV. Mr. Kumraju pulled up a loan agreement. And he talked you through a couple of the different terms that were on that document. He said there's a 3-year period. Those loans haven't matured. The government was premature in bringing this case. They can't possibly say that the loan program was a fraud if the money wasn't repaid. Ladies and gentlemen, you heard from victims. You heard from Lezhou. You heard from Jenny Lee. The 3-year period of that loan agreement, that's another distraction by the defense. And you know that because before the loan term had elapsed, those victims were sent extensions. Extensions they never asked for, extensions they never wanted to agree to. Those loans were extended against their wishes, and I do want to note one feature of the farm loan program extensions. Those were extensions entirely at the discretion of the borrower. Just think about that for a second. You borrow money. The person who lent it to you is owed it and interest to a certain point. And you have an agreement that says, actually, I can keep it as long as I want. You're not entitled to anything. That's not how a legitimate loan transaction works. And those contracts, those loan agreements, they don't say stock anywhere on them. Even though you know from Guo's broadcast from the victims and from the other evidence in this case that that's exactly what the farm loan program promised. Now why don't they say that? Because Guo and the farms were papering the transactions to hide them from the SEC. Guo knew that these stock promises were wrong from the start. The farm loan program was a fraud as soon as Guo lied on his broadcasts about these loans. That's not a rush to judgment as Mr. Kumraju mentioned yesterday. That's an analysis of the facts of the evidence. Who knows, though, maybe it was a typo just like he said about the Bugatti contract. Now, the defense is tried to underline the government's timeline of events, which outline Guo's motive for setting up his fraudulent enterprise and executing his fraud scheme. This is yet another distraction from the defense, and you should reject it. First, motive is not an element the government needs to prove. You do not have to find any motive to find Guo guilty of any of the charges against him. But there is motive here. Guo's motive is money. He wanted money. Guo is rich. And you may recall yesterday when the defense argued that Guo's lavish lifestyle was before and after the fraudulent enterprise began. And Mr. Kumraju predicted yesterday that I would stand up here today and I would say, of course he was maintaining his lifestyle even after the Hong Kong seizure. That's because he was stealing money from investors. Yes. That's exactly what I'm saying. Because that's what the evidence shows. Guo himself told his followers that he was rich as a way to assure them that he was not misusing their money. He broadcast from places of wealth, his penthouse apartment, his yacht. He was surrounded by things that were expensive. He wanted them to know that they could have the life that he had. Now during his summation Mr. Kumraju repeatedly implied that the government had harped on Guo's wealth during this trial. Had argued that Guo was hurting for money. And he then claimed that the government has failed to prove evidence of Guo's supposed poverty. Again. Another distraction, and one that mischaracterizes the government's position and the evidence. But, yes. The Hong Kong seizure of Guo's billions of dollars just a month before he launched the rule of law organizations where he lied to his followers to get them to donate money. That's a fact and evidence that Guo announced the farm loan program right after the SEC started investigating the GTV private placement. That's a fact. That Guo launched the Himalaya exchange weeks after the SEC reached a $500 million plus settlement with Soraka. GTV and Voice of Guo. That's a fact. That Guo filed for bankruptcy just 6 days after the PX litigation contempt order was entered. That's a fact. And that Guo launched the A15 and A10 investment offering in the wake of the government's seizure of more than $600 million of the money he had raised through his fraud enterprise. That's a fact. You have all of the evidence. You can draw your own conclusion. But don't let the defense distract you with arguments about Guo's wealth. It is not a crime to be rich. But it's certainly not a defense to the fraud crimes that Miles Guo committed. Your common sense alone tells you that the suggestion that rich people would never defraud anyone for more money. That's ridiculous. So let's talk briefly about the Himalaya exchange which Mr. Kumraju brought up today. He said that the Himalaya exchange was intended to help people move their money more easily. Well, that's true. But one problem. The movement was one way. It was into the exchange and rarely out. It was difficult for anyone to get money out of the exchange, nearly impossible. Now, Mr. Kumraju showed you a couple of summaries of a few redemptions that happened through the exchange. He said, "Look. This proves that the exchange was working. Just think about what the exchange was supposed to be." Miles Guo promoted it as a cryptocurrency platform. He said you can use this to buy things. You can use your HPay app to buy things. You can freely exchange money with other people. What have you learned about the Himalaya exchange during this trial? It was a glorified Excel spreadsheet. There was no blockchain. There was barely an internal ledger. They maintained numbers of the money that came in on a file. And they could change the price that was displayed on the website on that file. All to make it seem like a legitimate platform to encourage people to send money to it. What else did you learn from the victims who testified in this case? Some of them who had Himalaya exchange accounts never had access even to those accounts. They sent money to the Himalaya exchange they couldn't even verify was there. Money that they were never able to take out. Money that Miles Guo held hostage when they wanted to get refunds of their other investments in his schemes. Money that Guo stole from them in order for them to get a return on their G Club funds. Mr. Kumraju also mentioned today that there's no evidence that Miles Guo has any connection to the Himalaya exchange. I'm not going to spend much time on that because that's absurd. Look at his own statements, Z9. That's the summary of Miles Guo's statement. You should look at that for all of the schemes. But remember what we said, in Z9 Miles Guo said in a broadcast, Brother 7 designed H-Coin. Brother 7. Miles Guo. He himself said that he was responsible for the Himalaya exchange. And just today, as Mr. Kumraju mentioned, Miles Guo sent Lian Li to go to the Himalaya exchange. He sent her there to audit the books and records to look at the finances of the exchange. Why would somebody with no connection have an interest in going and seeing what's going on with the money? He wanted to know what was happening because it was his exchange. He needed somebody to go and find out where his money was. And you heard a lot during this trail about the promises of gold, 20% backed by gold, a stable coin. Enough money 1-to-1 so that there's never any risk of losing your investment. Now Mr. Kumraju said this no gold thing is confusing. It's not confusing. It's criminal. So what distraction did we have today? Well, he brought up one bank record with 2 transfers to a company called Sharps Pixley. And from that Mr. Kumraju said Sharps Pixley is a gold company. They bought gold. They were trying to set up a system of having gold backed for the Himalaya exchange. Ladies and gentlemen, that's the theme you've been hearing consistently throughout this trial for each of the schemes. They were working on it. They were trying to put it in place. They were trying to get G Club member benefits. They really wanted to get the cryptocurrency up and running. They were working on the blockchain. They were going to buy gold. It's simply a distraction. It's not true, and you know that. Now, briefly, the Himalaya exchange redemption that we looked at that was on the summary chart from the defense summary witness. First of all, to describe those as redemptions, that's the defense's term. That's what was in the wire transfer information, but we don't know how that got there. The white papers don't define redemptions in connection with H-Coin or HDO. Those are simply withdrawals from the accounts. And, in any event, you know why there were limited withdrawals from those accounts. It's the same reason that there were limited refunds given to G Club members. Because eventually when someone complained enough, they decided, let's give some of the money back so that nobody realizes this entire thing is a house of cards. Let's just let a little bit slip out so it looks legitimate so we can keep going. Now we talked a bit today about the bank records. Mr. Kumraju had brought up one of our summary charts yesterday and again today. He said, look at these. These money movements, this doesn't show anything. You can't prove that every single dollar that came in through the farms went to this yacht or to this aircraft. The government does not have to prove at all that Miles Guo used the fraud proceeds. All we have to prove is that he conspired to get the fraud proceeds, but he did use them. He used them for luxury car expenses and yacht expenses. He used them to send $20 million to a Swiss bank account held by his son Miles Guo. And you know that Miles' son Guo then took that $20 million. And that's some of the money that he funneled back to the family office businesses. Those are the bank accounts that funded Miles Guo's lifestyle. You've seen the evidence. You've seen the money movements. This is a blatant attempt to distract you from the extensive web of money laundering. It's not a coincidence that money went from the farm loan program into William J.'s slush fund at the ACA Capital account in Abu Dhabi. And it's not a coincidence that money then went from ACA Capital back to the Guo family offices. Now today Mr. Kumraju brought up the defense summary chart. This is a summary chart that related to the GTV investment. And he said the government has all of these scary summary charts of all the money. They're just inundating you with all of these charts showing money bouncing around from place to place. He said that half a dozen times. Do you know why those charts scare Miles Guo? Because they entirely unmask his sophisticated criminal enterprise. Let's focus on the GTV summary chart that Mr. Kumraju showed you. He said to you that Ms. Espinosa's testimony was that Mr. Skirik's hand-drawn chart was fair and accurate. Fairly and accurately showed the transaction into the Hayman Fund. That is not correct. That is not what Ms. Espinosa testified to. She said that it omitted transactions. It did not accurately describe money movements. And you know exactly what it omitted. It omitted the internal transfer, the cleansing transfer, the clear evidence of money laundering.
Continued on next page.
Ms. Murray said, as I mentioned, the G Club's fraud, that fraud is the offer of stock in exchange for money. It's the lie the people who send money to G Clubs will get stock. That's the G Club's fraud. But we spent so much time on it, let's talk about the Mawa residence. The $24.5 million Darlington estate that Guo bought with G Club's money and then renovated for himself and his family. The defense cannot deny that the Mawa residence was bought with G Club's money. You saw the flow of funds. Tracing the money from Crane to Aaron Mitchell's law firm escrow account to the payments for the mansion. So because they can't deny the source of the money that was used to buy Mawa, they made various conflicting claims about the intended purpose of Mawa. They claim it wasn't another Guo family home. He already has a $70 million penthouse and an estate in Greenwich. Why would he need a third house? And in New Jersey? No. They say it was a base for the NFSC. Or wait. Was it a clubhouse for G Clubs? Today, it was an investment for Hamilton. It's really hard to know which story they want you to believe. But what you do know is they don't want you to believe the truth. It was Guo's home. He and his wife toured it with Christine Frosini. He bought it, setting up Scott Barnett, his head of security, as the unwitting owner on paper, the manager of the tourist fund entity that legally purchased it. Then Guo's lawyer, Aaron Mitchell, hired Amy Buck to manage payments of the more than $14 million in renovations and furnishings. All paid for with more G Club fraud proceeds, all hand-selected by Miles Guo. Just remember the evidence that you saw, including the videos of Miles Guo from his own phone, where he personally directed the renovations to the mansion. He was circling the floor plans for his wing, his wife's wing, his daughter's wing, and his son's wing. He was explaining in detail how closets should be combined, how rooms should be arranged. And you didn't just see and hear the defendant directing these changes, you also saw bill after bill. Document after document, referencing May's bedroom, that's May Guo, his daughter. Referencing the madam's closet, that's his wife. Scott Barnett told you the mansion was a mess during the extensive renovations. But he also said, and this is directly contradicting what the defense wanted you to believe today. He said that Miles Guo still went there a few times a week. He said Miles Guo would sleep in his bedroom, in his wing of his mansion for up to 4 to 5 night stretches in a row. And remember what AUSA Finkel showed you yesterday. His personal things were at the mansion. His medicine, his identification cards. This was one of his homes. The defense also said, well, it's not a big deal that Ms. Reyes, the CEO of G Clubs, didn't know about Mawa. There was a reason for that. That wasn't her role. That was Hamilton's investment. You heard from Ms. Reyes that she was aware of the other assets that were purchased with G Club's money. Now, those, like Mawa, were not actually for G Club's members. They were for Miles Guo. But this, the Mawa mansion, the $40 million collective investment of G Club's member funds that Miles Guo stole for his own purpose. She was never read into that one. Even setting all of those points aside. Even if Guo had bought Mawa as a G Club clubhouse, he never disclosed that G Club investor money would be used to buy it. He said that individuals who paid for G Club's memberships would get stock in GTV or in G Fashion or in G Club. He did not say they would get partial ownership in a mansion or use of a clubhouse. His lies about Mawa are a crime. Mr. Kumraju also pointed you to certain disclaimers for the various businesses that Miles Guo promoted investments in. He said that the victims should have considered the full mix of information behind these investments. They should have read the fine print. That's an improper argument and it provides no defense to Miles Guo, for what he did. I want you to remember Judge Torres's instruction on this point. The instruction was, in determining whether a scheme to defraud existed, it is irrelevant whether a victim might have discovered the fraud if she, or it had looked more closely or probed more extensively. A victim's negligence or gullibility in failing to discover a fraudulent scheme is not a defense to wire fraud. Yet another distraction that you can set aside. The defense consistently has claimed, as they did today, that all of these investments were intended to further the movement. To further the political agenda. Let's talk about the protests for a second. Think about who was protested. Think about where the protests took place. They didn't take place at the Chinese embassy. These aren't protests that are targeting the Communist Party. No. The protests took place at the SEC. They took place at the bankruptcy trustee's home, his office, and the homes and workplaces of his family. They were directed at people who were trying to take Miles Guo's money. These are not activities of a political movement. These are activities directed by a fraudster who wants to keep his money for himself. And how does this political agenda point that the defense is putting forth to you, how does that explain Crane? Crane was simply a way to bring in G Clubs and Farms money and to move it offshore. It had nothing to do with politics or political activism. But as with so many different things in this case, Guo wants it both ways now. When it's helpful to Miles Guo to claim that the NFSC and the whistleblower movement are entirely separate from the G series, that's what he does. When it's helpful for him to collapse them, as he's argued here, that's what he does. He's an opportunist. He's a fraudster. And what about Haytham Khalid's recordings? The defense barely mentioned them. Either with Mr. Khalid or in the nearly 4 hours of summation that you heard yesterday and today. But you listened to those. Mr. Khalid explained them to you. Are those recordings of the defendant talking about his political activities? No. In those recordings, he is demanding the movement of investor money. He is controlling his criminal fraud enterprise. And Mr. Kumraju, as I mentioned, briefly acknowledged the recordings today because he had to. It would be far too obvious if he didn't mention them at all. But what did he say? He said, the recordings are actually a defense for Miles Guo. They show he didn't control G Clubs because he told people to do something and it didn't happen immediately. That's proof that Miles Guo is somehow innocent. You know that that's not true. But even taking a step back, ask yourself one fundamental question. If he didn't control G Clubs, why was he on so many calls about G Clubs money? If he's just a spokesperson, what is his role in talking about the tens of millions? The hundreds of millions of dollars of G Club funds that are locked up at Crane? It does not make sense. There is one reason, and one reason alone, that he was on those calls, because he is in control. And the argument that the transfer is not happening immediately is proof somehow that Guo didn't control G Clubs. You know that's inaccurate too. Because the transfers did happen. It took a couple of days. They had to get around some legal red tape. But what Miles Guo wanted, Miles Guo got. Let's briefly listen to a couple of those recordings. This is 417. We went over this yesterday with AUSA Finkel. But again, bring to this the context that you have from all of the evidence in this case. April 28, 2021. It's a meeting among Guo, Yvette Wang, William J.E., Haitham Khaled, and Alex H., the G Clubs' financial controller. The defendant, Miles Guo, is instructing Yvette and William to order Harun He, the UBO of G Clubs, to send $100 million worth of G Clubs money and farm loan money abroad. You heard him in this call demand that the money be moved quickly. And when he got pushback. When Yvette and William said to him, "We have to paper this." What would a normal company do? We need to do what a normal company would do so the transfer goes through. You heard how Miles Guo, the boss of this criminal fraud enterprise, responded. Regardless of whose name was on bank accounts or corporate documents, you know that Miles Guo controlled G Clubs. And he controlled the money.
Audio played.
Ms. Murray said, "That doesn't sound like a spokesperson to me. That's the boss of a criminal enterprise. And he's still at it a week later. They are still trying to figure out the transactions. They are still trying to figure out what agreements they need to paper these transfers." On May 6, 2021. Khaled recorded more calls with Miles Guo, where Guo again directed Khaled to send the G Clubs and the farm loan money that was in Crane's account to William J.E.'s foundation, to Hamilton Capital. In one of those calls, Guo told Khaled he must send the money wherever he's ordered to. And when Khaled explained that the transfers are not covered by Crane's escrow agreement with G Clubs, Guo demanded to get G Club's lawyer on the phone. And he called bullshit.
Audio played.
Ms. Murray said, "Pause that." Says no, this is Guo. No, you need, if they said the investor money. He essentially says they give the order, you send the money to go anywhere. You must send it anywhere. You can see Khaled says to him, "Correct, but I can only send it. I only have an escrow agreement with one company." And Guo says, "No, if they want you to send it to a third party, you have to send it to a third party. The foundation. William J.E.'s company." Guo says, "They make the order to give you, you have to send it anywhere. You must send it anywhere." And again, Khaled asks him, "Which foundation?" "I'm confused." Guo confirms. William's foundation, the fund. And when Khaled says, "No, I only have an escrow agreement with G Club. I can only send the money to G Club," William jumps in. He says, "Well, you take instructions from G Club, right? You have an escrow agreement." And then Guo says, "What?" Khaled explains. The lawyer said I can't do it." Guo says, "Which lawyer said that?" "Who?" And when Khaled explains that it's Ana Izquierdo, the in-house G Club's lawyer, Guo demands that they call Ana. He says, "Call Ana now. See if we can play this one."
Audio played.
Ms. Murray said, "The phone rings. Ana doesn't answer. And Guo yells at Gladys Chow. You've heard about Gladys Chow. She was one of his assistants. It's translated here because it's Mandarin on the recording. He says, "Find lawyer Anna's phone number for me." Again, not a spokesperson. This is the boss. And then he calls bullshit.
Audio played.
Ms. Murray said, "By the way, when you go back and deliberate, take a look at the transcripts for these calls and meetings. The Khaled recordings. It's the 400 series. You will notice that there is no discussion of political activism. There's no discussion of G Club's member benefits. These are calls about money. About hundreds of millions of dollars of money, about moving it offshore. About getting it into different bank accounts. They are not about the members. They are not about the whistleblower movement. They are about the only thing that Miles Guo cares about, money. And you should also take a look at how Guo refers to the money in those calls. Not as membership fees. Not as money from fellow freedom fighters or comrades in arms. No. As investor money. And keep in mind, these are calls that Miles Guo never thought anyone would hear. These aren't his broadcasts. He's not wearing a Brioni suit. He's not drinking tea in his Sherry Netherland penthouse. He's not riding around on his yacht talking about get rich quick, believe in me. I'll personally guarantee everything for you. These are the true Miles Guo, the boss of a criminal fraud enterprise. One other point that Mr. Kumraju raised today was about the government's witnesses, in particular. The insider witnesses. The people who were intimately involved with the businesses that Miles Guo used to raise money, Haitham Khaled, Limari Reyes, Jesse Brown, Yali. These insiders were pawns. They were used by Miles Guo. And like his victims, they believed him. They believed in him. When he told them to do something, they thought they were doing it in furtherance of legitimate businesses. They thought they were doing it for valid purposes. And those insiders, like the victims, they got nothing. Miles Guo got everything. He fooled many of his employees. He fooled many of his victims. Don't let him fool you. Ladies and gentlemen, the defense wants you to ignore the evidence in this case. They want you to brush aside the defendant's broadcasts and statements where he promotes all of the schemes of his criminal enterprise. Where he promotes GTV, the Himalaya Farm Alliance, the Farm Loans Program, G Clubs, the Himalaya Exchange. They want you to ignore these simple facts which the government has proven beyond a reasonable doubt. The defendant lied to people. He offered them stock and other things in return for their investments. And he assured them that both their investments would make them money and also that he would personally guarantee them against any losses. They want you to ignore that the defendant continued to personally guarantee them against losses. Even after he filed for bankruptcy in February of 2022. They want you to ignore the victims you saw and heard during this trial, victims who, one after another, said they had followed Miles Guo. They believed everything he said. But eventually, they woke up. Eventually, they realized, when they had trouble getting their money back or when he blacklisted them and called them CCP spies. They realized that he had lied to them. What Mr. Kumraju is asking you to do is to pick out one dot at a time. A single piece of evidence from each scene in the picture of this trial. Some from Rule of Law, a few from GTV. A couple more from the Farm Loans and G Clubs and the Himalaya Exchange. He's telling you to focus on each dot in isolation. And then he says that's not a picture at all. But you can't see the picture from inside the frame. So what the government is asking you to do is not to trust us, but to trust yourselves, to consider all of the evidence that you have seen and heard during this trial. To evaluate all of the dots together. And when you do that, you can see the picture clearly. It's a picture of the criminal fraud enterprise that Miles Guo built, that he controlled. That he used to tell lies and steal more than $1 billion from his victims. And when that picture is complete, there is one unmistakable conclusion: on all of the charges against Miles Guo, he is guilty.
The court said, "Members of the jury, I will now provide you with my final instructions before you deliberate. Please turn to page 68. Please turn to page 6843. Jury's duty to deliberate. Before you retire to deliberate, there are a few more areas I need to instruct you on. Your job is to decide whether the evidence establishes the guilt of the defendant with respect to the crimes charged in the indictment beyond a reasonable doubt. Deliberations must take place in the jury room with all jurors present. If any juror leaves the room, say for a bathroom break, all deliberations must stop and may resume only when every juror is present. In order to return a verdict, each juror must agree to such verdict. You have the duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement, if it can be done without giving up individual judgment. As jurors, each one of you must decide the case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. No juror should give up any honestly held conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. During the course of your deliberations, you as individuals should not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. For those of you who took notes during the trial, remember that any notes that you took are to be used only to refresh your own memory during deliberations. They may not be used as authority to persuade your fellow jurors as to what a witness did or did not say. Your notes are not superior to your or your fellow jurors' independent recollection. Those of you who did not take notes should not be influenced by the fact that another juror has taken notes. Rather, you should rely on your own independent recollection of the evidence. If there is a question as to what the testimony was or what my instructions to you were, you should ask to have that portion of the testimony or the instructions read back to you. Your notes and the notes of your fellow jurors are not a substitute for the official record or for the governing principles of law that I set forth. The court's transcript prevails over a juror's notes. You will have in the jury room a laptop with the exhibits introduced into evidence, should you wish to consult them. This laptop can connect to the large monitor in the jury room. If during the course of your deliberations, your recollection of any part of the testimony should fail, or if you should find yourself in doubt concerning my instructions to you on the law, you have the option to return to the courtroom for the purpose of having such testimony or instructions read back to you. If you want any further explanation of the law as I explained it to you, you may also request that from the court. If there is any doubt or question about the meaning of any part of this charge, you should send me a note asking for clarification or for a further explanation. Your requests for exhibits or testimony, in fact, any communications with the court, should be made to me in writing, signed by your foreperson, and given to one of the court security officers. Your foreperson, juror number 1, should write out your request and give it to the court security officer, who will deliver the note to me. Please write the note on one of the jury note sheets of paper and place it in an envelope for the court security officer. As soon as the attorneys, the defendant, and court staff are assembled in the courtroom, you will be called back to the courtroom and I will promptly respond to your request. During any readback of testimony, keep in mind how the witness's demeanor appeared to you as you observed the witness testify. In any event, do not tell me or anyone else how the jury stands on the issue of whether or not the defendant is guilty until after a unanimous verdict is reached. In order to reach a verdict, all 12 members of the jury must agree. Whenever all your members are in agreement on a verdict, you must report your verdict to the court. When you have reached a verdict, simply tell the court security officer you have reached a verdict, but not what the verdict is, and you will be promptly called back into the courtroom to announce your verdict. We have prepared a verdict form for you to use in recording your decisions. After you have reached a verdict, the foreperson should fill in the verdict sheet, sign and date it, then give a separate note to the court security officer outside your door, stating that you have reached a verdict. Do not specify what the verdict is in your note, and do not include the verdict sheet with the note. Instead, the foreperson should retain the verdict sheet and hand it to me in open court when you are called in. Because the trial jury is about to retire to deliberate, I now charge and I emphasize that there must be no further communication or contact between the trial jury and the alternate jurors. The alternates are not to discuss this case with anyone, including yourselves, nor are you to read, watch, or listen to anything from any source concerning anything touching on the subject matter of the case. Nor are you to permit anyone to discuss the case with you or in your presence. Nor are you to form any opinion as to the factual issues in this case. Nor are you to form or express any opinion as to the guilt or innocence of the defendant, unless and until such time as you may be requested to participate in the trial jury's deliberations. The alternates may leave the courthouse. However, you still may be called upon to replace a juror. So you must remain reachable by telephone, text, and email. And you must be able to return to the courthouse within 1 hour of being contacted by my staff. During your deliberations, lunch will be provided. You should not leave the jury room during deliberations unless you are instructed to do so. Are there any smokers on this jury? If you are a smoker, As I will not be in the jury room with you, should you desire a smoking break, you must make the request to your jury foreperson. Should the foreperson declare a break, the court security officer must be notified. During this break, all deliberations must cease. As smoking is not permitted inside the building, the smokers will be escorted by the court security officer outside the building to smoke. During this recess, the smokers outside the building cannot discuss this case, and the non-smokers in the jury deliberation room cannot discuss this case. You may not resume your deliberations until all of you are back in the jury room. Do you all understand? Counsel, do you wish to approach?
Ms. Murray said, "There's nothing from the government, Your Honor."
Mr. Kumraju said, "Nothing from defense, Your Honor."
The court said, "Now, I'm about to submit this case to you for your final determination. As I previously stated, the law and your oath require that you render a fair and impartial verdict without fear, favor, or sympathy. Now, take this case and in the fulfillment of your oath and in accordance with the instructions of the court, render a true and impartial verdict. Please escort the jurors out. Oh, one moment. I want to swear the court security officer."
Marshal sworn.
The court said, "All righty. The jurors may be escorted into the jury room."
At 12:04 p.m., the jury retired to deliberate.
The court said, "Please be seated. Given that there was no request to approach, may I assume that there are no exceptions to the charge?"
Mr. Kumraju said, "Nothing from the defense, Your Honor."
The court said, "I didn't hear you."
Mr. Kumraju said, "Sorry. Nothing from the defense, Your Honor."
Ms. Murray said, "Nothing from the government."
The court said, "So have you prepared the laptop with the evidence?"
Mr. Finkel said, "Yes, Your Honor. It's prepared. We could give it to your law clerk."
The court said, "All right."
Mr. Finkel said, "Just for the record, defense counsel has had an opportunity to review it. And I understand that defense counsel has consented to what's on the laptop, as have we."
The court said, "That is accurate?"
Mr. Kumraju said, "Yes."
The court said, "You don't have to remain in the courtroom. Just make sure that my clerks have your contact information, which I think they already have. Is there anything further?"
Mr. Kumraju said, "Not from the defense, Your Honor."
Ms. Murray said, "Not from the government."
The court said, "All righty. We will be in touch."
Recess pending verdict.
The court said, "Please be seated. It's 4:59. I have not heard anything from the jury. I don't have any notes. Is there anything before I dismiss them for the day?"
Ms. Shrofa said, "Not from the defense, Your Honor."
Ms. Murray said, "Not from the government." "Thank you."
The court said, "All right. If you'll have them brought in, please."
Jury present.
The court said, "I understand that the foreperson has a note for me?" Foreperson, "Yeah, we're just requesting some documents." The court said, "If you'll please hand that up. And please be seated." So this is jury note number 1. States the jury, request physical copies of transcripts, restatement of limiting instruction. It's signed by the foreperson and it bears today's date. I'm going to make this court exhibit number 1. So we will discuss your note and address it tomorrow morning. So your work for today has finished. You'll come back tomorrow morning and you'll start at least by 9:30. But of course, if you are all gathered together before 9:30, you can start at that time. So the old rule applies. You're not allowed to discuss the case amongst yourselves. Don't permit anyone to discuss the case in your presence. Don't read, watch or listen to anything from any source that touches upon the subject matter of this trial. Once everyone is all gathered together tomorrow, you can recommence your deliberations. Have a good evening.
Jury not present.
The court said, "Please be seated." So with respect to the first request, physical copies of transcripts, I would like to ask if there are particular witnesses and whether or not they're looking for the direct, or the direct and the cross, or just the cross.
Mr. Finkel said, "It's also possible, Your Honor." By transcripts, they mean transcripts of some of the recordings or the videos that are in evidence.
The court said, "Oh, that's true. I didn't think of that. Okay, So, yes, maybe it is merely, but don't they have those?
Mr. Finkel said, they have them electronically. They might want them physically to read, a hard copy.
The court said, okay. So then if you would prepare those hard copies, and I think it would be handy to prepare 12 of each.
Mr. Finkel said, we could do that.
The court said, is it too voluminous to do that?
Mr. Finkel said, we could do that. One of them is 200 pages long.
The court said, oh, that's very voluminous.
Mr. Finkel said, we'll prepare if it's okay with the court, we'll prepare several copies. We'll figure it out. We'll give the defense an opportunity to review them, obviously, in the morning, if that's okay with your honor.
The court said, yes. I don't mean that you should stay up all night Xeroxing.
Mr. Finkel said, we're used to it at this point. Why should tonight be different from any other night?
The court said, so then they ask for a restatement of limiting instruction. I don't know what they mean. I'm certainly hoping it's not a restatement of the jury charge. But does anybody have any ideas?
Mr. Kamraju said, I think it might make sense to ask them in the morning whether they are talking about, like your honor, it could be what Mr. Finkel said. It could be particular witnesses. Because the way I hear it is limiting instruction. And there have been a few over the course of the trial with respect to hearsay or something like that. So I think it might make sense to ask them to clarify because, I've never had a trial where we sent the entirety of the transcript back to them. That would seem odd. So I think it might make sense to ask them in the morning what they are talking about. And then assess whether they just want you to read or reissue a limiting instruction with respect to a particular witness's testimony or a particular item of evidence that's come in.
The court said, so what I'd like the parties to do is to identify the limiting instructions so that we have those handy for tomorrow morning. Is there anything else?
Ms. Schrofa said, Your Honor, I apologize. But it's unclear from the note if they mean transcripts of the trial or transcripts of the videos or transcripts of the recordings. Perhaps it would be prudent of us to ask the jury to simply say, could you please be more specific about which transcripts the court should send back to you? Because it could be we just send them the wrong transcript or we guess wrong. I think that might open up a Pandora's box down the road.
The court said, oh, I'm not suggesting that we simply hand them the transcript, the translations essentially. I'm not suggesting that we just give it over to them. I would ask them tomorrow morning. I just think that we should be prepared to do so. Now, with respect to the transcript of the testimony, that is not something that I think we should guess at this point. Hopefully, it is merely the translation.
Mr. Kamraju said, that makes sense to me, Your Honor. And in terms of identifying the limiting instructions, I guess we can identify the places in the transcripts where the court has given limiting instructions. And then based on what the jury responds for the inquiry, we can decide which limiting instructions need to be restated or said to them again or just provided with the transcript, if they are asking for them.
Mr. Finkel said, for the record, the government agrees with defense counsel in that we should clarify with the jury precisely which transcripts or translations they want, and also what they mean by limiting instruction. I think we're all on the same page.
The court said, I've never received a request for a limiting instruction.
Mr. Finkel said, as you noted, this is an unprecedented trial.
Mr. Kamraju said, well, and I think, Your Honor, I've never had that either. That's pretty confusing. Especially because there are different limiting instructions that apply to different testimony and exhibits, right? So I don't think, for all the same reasons, I don't think we can guess at which limiting instruction it is that they want to be restated. So we can identify the ones that exist and then figure it out once they clarify for us.
The court said, it's possible that they read the section about limiting instructions and may not know what we were referring to.
Mr. Kamraju said, that's true also.
The court said, I certainly hope it's not the whole charge.
Mr. Finkel said, Your Honor, just one question. Is it separate? We haven't seen the note. Is the note separated where it says this is request 1 transcript, and request 2 is the limiting instruction? or are they together?
The court said, so on the first line it says, we, the jury, request physical copies of transcripts, period. On the second line it says, restatement of limiting instruction. I will provide a copy of this to you, but they distinguish between the two things.
Mr. Finkel said, okay.
Mr. Kumraju said, even if they do mean, Your Honor, the entire charge. I think probably it would make sense even then to ask them if they can be more specific as to what they want.
The court said, I assure you I will do that.
Mr. Kumraju said, I assumed as much.
Mr. Finkel said, sorry, Your Honor, every judge has a different practice. Do they have a copy of the charge?
Court said, oh yes.
Mr. Finkel said, okay. So that's helpful to understand as we consider what they need. Okay.
The court said, I heard that in Judge Hellerstein's trial there was a request for a summary, a one-page summary of the RICO charge, so that's something perhaps to think about.
Mr. Finkel said, did Judge Hellerstein provide that?
The court said, apparently.
Mr. Finkel said, okay.
The court said, and I will be taking a look at it.
Mr. Finkel said, we will too.
The court said, okay, so you do not have to return to the courtroom until 9:30. I don't expect that they're going to be gathered together. Oh, wait a minute. Now I'm being told that they are usually all here by 9 a.m., so then you should be prepared to get started at 9 a.m., which would be better for all of us.
Mr. Kumraju said, is it Your Honor's intention to send a note back to them asking for clarification or to bring them out and ask?
The court said, going to bring them out and ask.
Mr. Kumraju said, okay.
The court said, now their answer, however, I'm going to send them back to write down their answer. I'm not going to take their answer in open court.
Mr. Kumraju said, right. No, the answer would come via note.
The court said yes.
Mr. Kumraju said, okay. That makes sense, Your Honor. Thank you.
The court said, all righty. Thank you and good evening. My brilliant law clerk suggested that perhaps they might be referring to the transcripts that they had in the jury box when they were listening to testimony, so something to think about.
Mr. Finkel said, Your Honor, if I may, does your staff still have those? Okay. So with respect to the binders, we wouldn't have to prepare new ones. Okay. Thank you. Thank you for keeping those.
The court said, all righty. Have a good evening.
Mr. Finkel said, thank you, Your Honor.
Mr. Kumraju said, thank you.
Adjourned to July 12, 2024, at 9:00 a.m.